Alrighty. I'd like to start by just touching on a point that Senator DeFrancisco made, and I'm sorry he's not here to respond or to hear this. It's not a criticism, just a clarification. He asked Ms. Andersen what the percentage of cases were in which she felt there was some impropriety or favoritism, and he suggested that possibly the small number, the small percentage, was indicative that maybe something was, if I understood correctly, was that things are not so bad, and there might be an acceptable sort of random level of impropriety or malfeasance. The fact is that the vast majority of cases provide no motivation for corruption. By definition, corruption occurs when there is a vested interest in the outcome. If a policeman arrests 100 drug dealers and then fails to arrest his younger brother, his corruption rate is not 1%, it's 100%, because that's where he had a motivation to be corrupt. And nobody is accusing Mr. Tembekian or Mr. Friedberg of doing this for sport. They do it because they have a vested interest. What exactly those vested interests are is not known to us, but we can only assume that they don't do it for sport. Having said that,
now you have 4 minutes.
Sir, thank you, Senator. Give me a break. Mr. Gold cites the rules of the grievance committees, that the rules of the grievance committees, I'm sorry, Mr. Gold claims that the grievance committees are governed by rules. The problem is not that there are no rules, the problem is that the rules are ignored, twisted and perverted. The New York State Judiciary is so dysfunctional and corrupt that their so-called ethics committees routinely break existing laws and capriciously create false laws without due process and with utter impunity. By doing so, they undermine the credibility of the courts, which is clear to everyone here. Their corruption is so absolute and flagrant that they don't even make an effort at the appearance of propriety. Instead, they spit in the face of citizens, the Constitution, and the universal tenets of justice. These committees use corruption both as a sword against their enemies and a shield to protect their friends. Complaints against lawyers with connections are brazenly whitewashed or ignored. I didn't learn this from anybody else. This is from my experience. Decent lawyers are sanctioned or disbarred with no legitimate reason, simply because they dare to oppose the corrupt power structure. Likewise, the Commission on Judicial Conduct routinely whitewashes and dismisses complaints against judges without any investigation or explanation, and judges who dare to challenge the system are punished. To compound the problem, no attorney will touch cases of corruption against crooked attorneys or judges because they know this means professional suicide. The corruption is not only deep and wide, it extends to the highest office of the judiciary. The Chief Judge of New York State, Jonathan Lippman, who I respectably submit was shoehorned into office by a faulty confirmation process, is personally implicated in at least a dozen lawsuits and dozens more complaints regarding corruption. And those are only the ones that I know about. This is the head of the snake. We can talk about the tail or the middle, but this is the head of the snake. And before him it was Judith Kay. In his prior role as presiding justice of the First Appellate Division, Lippman appointed Alan Friedberg to head the Disciplinary Committee. Alan Friedberg, who had already earned his reputation as corrupt in his former position as chief counsel to the CJC. When Friedberg continued to run the DDC as corruptly as his disgraced predecessor, Thomas Cahill, Lippman received scores of complaints about Friedberg's corruption and incompetence. Lippman did nothing, and that is no surprise. In his previous position as administrative judge of the OCA, Jonathan Lippman had personally fired DDC investigating attorney Christine Andersen for reporting systemic felonious corruption at the DDC. He fired her for insubordination. But that's obviously a mischaracterization. No one can deny that the DDC protects guilty lawyers and attacks innocent ones. But what I'd like to address is how they do that, what are the methods that they use, and I think people will relate to many of these. I will be as brief as possible. All problems with the DDC arise from underlying conflicts. Mine had to do with I'm a musician, it had to do with a record that I made, and a lawyer tried to steal the rights from the record by writing and claiming that I was not the copyright owner. 6 months later, he changed his mind and said that I was the copyright owner, admitted that in a sworn document. Now, in the interceding 6 months, I could not get a record deal, and I was basically being threatened with the federal crime of copyright infringement. Turned my life upside down. 2 streams of systemic and coordinated official misconduct arose from my underlying dispute. One, my efforts to file disciplinary complaints against certain lawyers have been illegally obstructed by multiple government agencies, including the DDC, the CJC, the DDC, the DA's office, the Attorney General, and others.
You and I, we have had this dialogue, and you talked about these instances.
What would you like to know?
Exactly. I want to get to, you talk about whitewashing. What specifically was done that you consider to be whitewashing? We can get those specific incidents.
Good.
And what recommendations would you have to improve the system?
I appreciate your editing,
Thank you.
as always, Senator. Well, I'll make it very clear. 2 cases which I see as absolutely crystal clear. I mean, I'm not going to talk about stuff that's debatable with debatable facts. For example, this lawyer who wrote in a letter to my record company that I was not the owner of the record and that he was going to sue me for copyright infringement, 6 months later, admitted in a sworn affidavit that I was the copyright owner. By any definition of the word, the man was lying. And lying is against the rules. It's not against the law. I cannot sue him in court for lying. Maybe for fraud, possibly, but not for lying. Lying is an ethical infraction that is in the LCPR. It has a particular number. It's DR 1102. A lawyer or law firm shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Now, if you tell a record company that I'm not the owner of the record, and you know perfectly well, and 6 months later you say, yes, I knew that he was the owner.
We got that point.
Okay, I want to make sure that everybody understands there was no question. What did the DDC, what did Mr. Freed,
what did DDC do that was so...
Okay, what Mr. Cahill did was he asked for a response from the lawyer. The response came from the lawyer's boss, employer, and counsel at the time, Myron Beldock. Should be noted that
What did he do that was questionable to you?
Oh, okay, I'm sorry, yeah, okay. I was just going to note that Hal Lieberman, who preceded Mr. Cahill, was working at Beldock's office at that time. He went directly from the DDC, which I think gives some insight as to how the revolving door works here.
Your issue is that's conflict issues that you see.
Yeah, well, that's a conflict issue, but that's an aside. Just shed some light on what's going on behind the scenes. What happened, what Mr. Friedman did, well, what Cahill did, is he got the response from the lawyer, but the lawyer said, here's my response, it's 27 pages long, but Mr. Gallison can't see it, because he's considering suing me, and it may contain some information. This is, by the way, this is after months of delay.
But don't they send you a copy of his response?
Yeah, you're supposed to. But what they said, instead, they sent me the letter which said, the response is redacted and sealed. He said, we are attaching 2 versions of the answer from Mr. Greenberg. One is entirely deleted, redacted. That is page 3 to page 28 is redacted. The other is in a sealed envelope which neither you, the DDC, or Mr. Gallison is allowed to view. Now, the DDC booklet and the rules say that when and after a case is opened, and by sending the thing, they've opened the investigation, the complainant is required or encouraged to respond to the answer. And I wrote to Mr. Cahill and I said, well, how can I respond to something that's in a sealed envelope that I can't even see?
I mean, that's a very valid point in which you make. Let's go to the second incident.
Oh, okay. Let me just say that he said, do the best you can.
Okay.
So in response, I wrote a 40-page report, fully documented, 40 pages of text, hundreds of pages of exhibits.
So what actually happened to the case?
It was
it dismissed?
It was dismissed, and I wrote and I said, when you dismissed this, did you take into account the information that was in the sealed envelope, or did you just decide that I was lying? and they said, oh, well, maybe we made a mistake. We'll have it reconsidered. That's one of the things they do. They spend 6 months reviewing a case. Then they say, oh, maybe we goofed. We'll reconsider it. Then there's another 6 months or a year. So
I want you to kind of get. I got another minute left.
Please, just ask me the questions. I will try to. This is one case. The other case, and there are 5 lawyers and 2 judges. I haven't gotten to the CJC yet. The other case involved a lawyer, a guy named, which you've heard this story before, a guy named Friedman, Leon Friedman, who I complained to Cahill, and Cahill said, he wrote, the very words he wrote were, this attorney does not practice in Manhattan or the Bronx and is therefore not under our jurisdiction. I wrote him, I said, he does. He just does. I'm not making that up. Here's his letterhead. Here's the picture of the plaque over his door. Here's a recording of his secretary saying that's his sole law office. But he was fraudulently registered in the 10th District. I said, the fact that he's fraudulently registered in the 10th District doesn't have any bearing. 3 years, actually 3.5 years now, I have been contesting with Mr. Friedberg and his committee that 148 East 78th Street is in Manhattan and not in Suffolk County somewhere. Okay. They maintain that it's in Suffolk County. And they because by no account does Mr. Friedman have a law office in Suffolk County. Just doesn't.
Okay.
So that is just nonsense. I mean, that's the stuff that but what happened was they sent my complaint to the 10th District, where it was dismissed 1 week after it was sent. In April of 2006, it was never sent to Mr. Friedman. Now, what was the rationale behind not investigating? They said this is not a complaint about ethics. This is a civil complaint. Well, hold on a second. The entire complaint was enumerated in the precise language of the LCPR, the Lawyer's Code of Professional Responsibility. Every complaint was followed by a numerically a numbered description of the exact law and why my cases corresponded to those particular ethical rules. To say that it's not an ethical complaint is just ludicrous.
Okay.
But worse than that, they did not send me any confirmation. I did not know for 3 years. During the time, that 3 years, I was communicating with Mr. Friedberg, and he denied, he refused to answer the simple question of whether Mr. Friedman was practicing in the 1st Department or the 10th District, the 2nd Department. I sent him 15 letters, and I have a tape recording which I put on YouTube of him saying that he will not tell me, he refuses to tell me whether the lawyer is in his jurisdiction. That is the level of utter disregard for fairness and rules.
And I need you to, we need to end it. And I think I understand your point with the whole issue of the transparency issue and just basically the common decency and courtesy of just following up.
Well, no. Decency and courtesy is way more than I would demand. I'm talking about legal behavior.
Okay.
I don't care if he's decent or courteous to me. He has to respond to my. Finally,
the transparency issue is what.
Yes, not just transparency. Following the laws. I've got a list of the laws that Mr. Friedberg broke. And I just want to say, and with one thing, I was recently speaking to the chief clerk of the 2nd Appellate Division, Mr. Pelzer. And I have him on a tape recording saying the courts may dispense with the rules, with their own rules. That is not true. The senators can't dispense with their own rules. The citizens cannot dispense with their own rules. The president cannot dispense with his own rules. Thank you, sir.
Thank you very much. The next witness is